Good morning. Welcome to Conneaut Municipal Court. My name is Nick Irochi. I'm the judge, and this is your initial appearance on charges that have been filed against you. As you can tell, we have a number of students here from the Conneaut Middle School. They are here as part of a court student program called My Day in Court. My Day in Court is in its 36th year in Conneaut Municipal Court. It's one of the longest running programs, court student programs in the state of Ohio, if not the longest. It's a program that is run by actually sponsored by the Conneaut Rotary Club. We welcome the students here today. They're here every Tuesday morning, and they know that they're not participants and that they're going to be silent throughout these proceedings. So, anyways.
All right. Pause right here. This part may sound routine, but this is one of the most important moments in any criminal case. These rights protect people from accidentally talking themselves into trouble. Miss even one detail here, and it can cost you later. Question for you. How many people do you think actually listen during this part?
I'm going to read all of you your rights. Together I'm going to read your rights, and then I'm going to call your case up individually. When I call your case up, you can take a seat in this blue chair here. If you have any questions regarding the rights I'm about to read to you, you can ask them at the time I call your case up, and then we'll address your case and the charges filed against you. So please pay attention to the rights I'm about to read to you. You do have a right to a copy of the criminal charge or complaint filed against you. You should have already received those. If you have not received your charges, please let me know when I call your case up. You also have a right to be informed of and to understand the nature and the elements of the charge or charges filed against you. You also have a right to know the potential penalties that could be imposed, and I will explain those potential penalties to you when I call your case up. You have a right to remain silent and not to say anything during this hearing that might incriminate yourself. Any statement you make could be used against you. You also have a right to a trial to the court. And if you're charged with an offense that carries a possible jail sentence, you also have a right to a jury trial, provided that you timely file with the court a written demand for a jury trial. At trial, you have the right to confront and ask questions of any witness who would testify against you. You also have a right to use the court process to secure the attendance of any witness who you would want to testify on your behalf. At trial, you have the right to be proven guilty beyond a reasonable doubt and a right not to testify. You also have a right to have an attorney represent you in your case, and if you're charged with an offense that carries a possible jail sentence, you do have a right to court-appointed counsel and to have a lawyer assigned to represent you only if you cannot afford one. If you do qualify for court-appointed counsel, there is a $25 application fee and a $50 cost reimbursement assessment that apply. You also have a right to a continuance of this initial appearance hearing in order to retain the services of your own attorney or to consult with your own lawyer. If you are convicted of any of the charges filed against you or any related offense, you have a right to appeal the conviction or sentence. That must be done within 30 days of the conviction, and you would be entitled to a court-appointed attorney in the Court of Appeals if you receive a jail sentence and cannot afford a lawyer. Now, if you plead not guilty today to any of the charges filed against you, I will set your case for further proceedings after today, and I will set a bond. A bond is set by the court to ensure your appearance at all future proceedings, as well as to protect public safety. And today you have the right to a reasonable bond. If you are not a citizen of the United States, you're hereby advised that conviction of the offense to which you could be pleading guilty or no contest may have the consequences of deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States.
This is where things get sneaky for a lot of defendants. No contest sounds harmless, but notice what the judge just said. You're still found guilty without evidence. The only real shield is that it can't be used in civil court later. Would you risk that just to get the case over with?
Now, each of you have 3 plea options available with respect to each of the charges filed against you. You can either plead guilty, not guilty, or no contest. If you plead guilty, that is a complete admission by you to the offense charged. If you plead guilty, the court will find you guilty, and then I will impose sentence. The second option is you can plead not guilty. If you plead not guilty, that is a denial by you to the offense charged. And as I said earlier, if you plead not guilty, I'll set your case for further proceedings after today, and I will set a bond. The third option is you can plead no contest. If you plead no contest, that is not an admission of your guilt, but it is an admission by you of the truth of the facts alleged in the complaint filed against you. If you enter a plea of no contest, this court will find you guilty, and I will impose sentence without any evidence being presented against you. However, the plea of no contest cannot be used against you in any later civil or criminal proceedings. Court is now calling State of Ohio versus Thomas Robert Puffer, case number 26 CRB 2. Good morning.
Good morning, Your Honor.
Okay, Mr. Puffer, your charges actually stem from an indictment that was handed down by the Ashtabula County Grand Jury. After felony charges were bound over, the grand jury, after presentation, actually did not indict you on felony offenses, but actually indicted you on.
This right here is a quiet but massive win for the defendant. A grand jury looked at felony allegations. Nope. That downgrade alone can mean the difference between prison time and walking free. Behind the scenes, this is where good lawyering really matters.
2 misdemeanor offenses, and those misdemeanors have now been transferred to this court to handle. So have you received copies of that indictment?
Yes, sir.
Okay. Did you understand all of the rights and plea options I explained to you?
I did, Your Honor.
Do you have any questions regarding any of those?
No, sir.
Okay. So the first charge filed against you is obstructing official business. That is a second-degree misdemeanor. If convicted of this offense, you face a maximum 90 days in jail and a maximum fine of $750 plus costs. Do you understand that?
Yes, I do, Your Honor.
The second charge is a watercraft and waterways violation, which is only a minor misdemeanor. That is punishable by a maximum $150 fine and court costs. It is not a jailable offense. Do you understand that?
Yes, I do, Your Honor.
Okay, we'll start with the first charge of obstructing official business, a second-degree misdemeanor. How do you plead to that charge?
Not guilty.
Okay. And the second charge of a watercraft or waterways violation, a minor misdemeanor, how do you plead?
Not guilty.
Okay, the court will accept your not guilty plea. I do recall, Mr. Puffer, that you were represented by William Bobalski in at the felony matter. Is he still representing you?
Yes, sir.
Okay. As this was an indictment from the county grand jury, I do not have a bond recommendation from the law director, but let me see. Back when the felony charge was filed, he requested bond set in the amount of $20,000 personal recognizance. The allegations at that time the felony was filed was that on October 5th, 2025, the defendant was observed tampering with containers of alcoholic beverages at the scene of a boat crash near the PNC Dock Company slip. And just for the record, Mr. Puffer, where are you residing?
7901 Baxter Drive. And it's listed as Conneaut, Ohio.
Okay. Okay, based on the new charges, I'm going to set bond in the amount of $10,000 personal recognizance.
Notice how the judge doesn't just set bond, he sets behavior rules. Alcohol ban, random testing, mandatory treatment. Translation: one bad decision and this turns from freedom into handcuffs fast. Do you think these conditions are fair or too strict?
I'm ordering you not to consume or possess alcohol or drugs. You are subject to random chemical testing by probation and law enforcement. Are you currently receiving the treatment services? Yes, you were at the Erie VA, right?
Yes, sir.
Okay, I will order as a condition of your bond that you successfully comply with any and all treatment recommendations at the Erie Veterans Administration. I will set this case for a pretrial conference in the near future when Mr. Bobolski is available. Okay, Mr. Puffer, I'm going to explain this to you, and I'm sure you're aware of it, but I want everybody to pay attention to this. If you plead not guilty to your case, or to the charges filed against you. Mr. Puffer, when you leave the courtroom, you're going to go to the clerk's window. They're going to give you a date and time for your next hearing. If you fail to appear for that hearing, or if you fail to abide by the conditions of your bond, in other words, if you fail to stay drug and alcohol free or fail to successfully comply with your treatment at the Erie VA, I could revoke your bond, I could issue a warrant for your arrest, and in addition, I could order you to pay $10,000, in your case $10,000, to the state of Ohio as a penalty for violating your bond. Do you understand that?
I do, Your Honor.
Okay. Do you have any questions?
Not this time.
Okay, sir. So you can go to the clerk's window. They'll take care of you. Thank you. Okay, the court is now calling City of Conneaut versus KW Enterprise LLC, case numbers 26 CRB 4 and 26 CRB 6. Good morning.
Good morning, Your Honor.
Give me 1 second, sir. Here, give me 1 second. Okay. And for the record, sir, what is your name?
Kevin Wu.
And is it W-U?
Yes, correct.
Okay. And what is your relationship with KW Enterprise LLC?
I'm the owner, Your Honor.
Owner? Okay. Okay, Mr. Wu. On behalf of KW Enterprise LLC, have you received a copy of the complaints filed against the LLC?
Yes, Your Honor.
Okay. Did again, when I use the word you, I'm actually, you're speaking on behalf of the LLC, okay?
Okay.
So have you received a copy of the, you've already said you've received a copy of the complaint, but do you have any questions about the rights or the plea options I explained earlier?
I do, Your Honor.
Okay, go ahead.
What's the difference for no contest and pleading guilty for the failure to pay the occupancy permit?
Sure. So a guilty plea is a complete admission. In other words, you're admitting to everything alleged in the complaint. And then if you plead guilty, I'll find you guilty and then I'll impose sentence. A no contest plea is where you're not admitting your guilt, but you're admitting to the truth of the facts contained in the complaint. And normally no contest pleas are entered where somebody just wants, even though they have a defense to the case, they want to just end the case.
Right.
Or where there's potential civil liability. In other words, if they don't want a guilty plea to be used against them because they might get sued. So a no contest plea means it couldn't be used against them in any later lawsuit. So does that help?
Yes.
Okay. Do you have any other questions?
No, Your Honor.
Okay. So in case number 26 CRB 4, the LLC is charged with one count of what's called rental permit required. That is an unclassified misdemeanor. Now the allegations contained in the complaint indicate that the offense took place between June 6th of 2025 and January 6th of 2026. So I haven't calculated all of those days. But suffice to say, July, August, September, October, November, December, January, that's 7 months. So the reason that's important.
This is where business owners start sweating. $1.50 per day doesn't sound bad until the judge does the math out loud. Suddenly, you're staring at thousands in fines. Small compliance issues can snowball fast, especially when cities enforce by the calendar.
Because the potential penalty the LLC faces is a fine of up to $50 per day of the violation. So 7 times 30 is roughly 210 days. 210 days times 50, that's the maximum fine the court could impose if convicted of this offense. Do you understand that?
Yes, Your Honor.
In 26 CRB 6, the LLC is also charged with a rental permit required. Now this date range is between May 15th of 2025 and January 6th of 2026, so it's a little longer period of time. Again, a maximum penalty of up to $50 per day for the length of time of the violation. So do you understand the maximum potential penalties you face on that charge?
Yes, Your Honor.
Okay, we'll start with the 26 CRB 4, and this involves property located at 500 West Adams Street in Conneaut. How do you plead to that charge?
No contest.
Okay, and then in 26 CRB 6, this involves property at 542 Madison Street in Conneaut. How do you plead to that charge?
No contest.
Do you understand by pleading no contest that you're waiving all of the trial rights that I explained to everyone earlier?
Yes, Your Honor.
Did you understand those rights?
Yes, Your Honor.
Okay, you don't need me to explain them again? Where you have a right to cross-examine witnesses and to confront evidence presented against you. You would have a right to testify or not to testify without any negative connotation. You would have a right to subpoena witnesses to testify on your behalf. You would have a right to be proven guilty beyond a reasonable doubt. All of those are trial rights you would be waiving by pleading no contest to these charges. Is that what you wish to do?
Yes.
Okay, you'd also be waiving your right to an attorney by pleading no contest to these charges. You're not entitled to court-appointed counsel, but you do have a right to hire your own attorney at your own expense to defend you in these cases. So by pleading no contest, you'd be waiving your right to an attorney. Is that what you wish to do?
I'm sorry, I'm just confused. So if I plead guilty and you guys do charge me, I could get an attorney if it goes
Okay,
further?
so these questions that I'm asking you are, whether you're waiving your right to a trial and whether your right to an attorney applied, whether you plead guilty or no contest.
Okay, I'll plead no contest.
Okay, but I understand that's what you pled, but I want to ensure that you understand by pleading no contest that you're waiving these rights. Your right to trial and your right to an attorney. Is that what you wish to do?
Yes, Your Honor.
Okay. Are you entering these pleas knowingly and voluntarily?
Yes, Your Honor.
Okay, no contest pleas require an explanation of circumstances. So I'm going to read what the law director has submitted in the bond recommendation to see if this is sufficient for an explanation of circumstance. In 26 CRB 4, the prosecutor or law director alleges that on or between June 6, 2025 and January 6 of 2026, the defendant failed to obtain a rental permit for its property located at 500 West Adams Street in Conneaut. And in 26 CRB 6, the law director alleges that on or between May 15, 2025 and January 6 of 2026, the defendant failed to obtain a rental permit for his property at 542 Madison Street. Do you agree with those explanations?
Yes.
Okay.
I feel it's okay.
Okay, and I do find those brief explanations sufficient to accept a no contest plea. I do find the defendant's plea of no contest to both charges to be knowing, voluntary, and intelligent. The court will accept the guilty pleas to those charges, or no contest pleas to those charges, and I will therefore find the defendant guilty of both offenses. Okay, before I proceed to sentencing, Mr. Wu, has everything been worked out with the city about the permitting?
Yes, sir. Yes, Your Honor.
So you have received permits for this property?
Just waiting on inspection. I did pay the permits.
You did pay them? Okay. And I do see, oh, that's Secretary of State. See, the reason I ask is because in cases like this, I'd like to in cases like this, I'd like to perhaps defer sentencing, not sentence you today, and schedule sentencing in maybe in about 30 or so days to give you time to make sure you're all permitted, you're inspected, and the city finds you in compliance. But that would require you to come back. And in a situation like this, where you could be fined up to $50 per day over a 6-month period, I would like to have input from the law director's office as to what their recommended sentence would be. So,
I thought that's what they were telling me today, because I talked to them this morning and paid. They said they were going to send it to you, so I thought.
Well, I do see something in one of your other files that shows that you did get the permit, but I don't have the prosecutor here to tell me what they're recommending in the way of a fine. Do you follow me?
Yes, Your Honor.
And the prosecutor's never here on Tuesday mornings for these hearings. He's here every other day at every other time, but for these hearings, he's not required to be here. So, is it an inconvenience for you to come back again in about 30 days?
No, it's not.
Okay, so what I'm going to do is I'm going to defer sentencing for about 30 days. On each case, I'll set bond in the amount of $1,000 personal recognizance, and I'll indicate that the clerk will schedule what we call a sentencing hearing in roughly 30 days in both these cases, with the law director to be present. Okay? Okay, sir, do you have any questions?
No, Your Honor.
Okay, so when you leave the courtroom, you go to the clerk's window and they'll take care of you, okay?
Thank you.
Thank you. Have a great day. Court is now calling City of Conneaut versus Cayman Chabot. Did I say that correctly?
Yes, Your Honor.
Chabot, case number 25 CRB 323. Good morning. Okay, Mr. Chabot, did you understand all of the rights and plea options I just explained to everyone?
Yes, Your Honor.
Do you have any questions regarding those?
No, sir.
Did you receive a copy of the criminal charge?
Yes.
Okay, you're charged with 1 count of junk and unlicensed vehicles. That is a fourth-degree misdemeanor. If convicted of this offense, you face a maximum 30 days in jail and a maximum fine of $250 plus costs. Do you understand the maximum potential penalties you face if convicted of this offense?
Yes, Your Honor.
Okay, so with respect to this charge, how do you plead?
No contest.
Okay. You understand by pleading no contest to this, Mr. Chabot, that you're waiving your right to a trial, which includes your right to cross-examine witnesses and to confront evidence presented against you. You'd be waiving your right to testify or not to testify without any negative connotation. You'd be waiving your right to subpoena witnesses. You'd be waiving your right to a jury trial. You'd be waiving your right to be proven guilty beyond a reasonable doubt. All of those are trial rights you'd be waiving by pleading no contest to this charge. Is that what you wish to do?
Yes, Your Honor.
You are not represented by an attorney today. By pleading no contest, you would be effectively waiving your right to have an attorney represent and advise you in this case. Is that what you wish to do?
Yes, Your Honor.
Are you currently under the influence of any drugs, alcohol, or prescription medications that might affect your thinking?
No, sir.
Are you currently on probation, parole, community control, or post-release control with any court?
No, sir.
Has anyone made any promises to you about what your sentence would be in order to induce you to plead no contest to this charge?
No, sir.
Okay. You're not sure? Has anybody told you, or promised you what your sentence is going to be?
No. I mean, I found out about this because my mother told me about it. I had no clue. I had
But
no-
nobody's promised you or told you,
No.
here, this is what you're going to receive in the way of a sentence if you plead no contest.
No, sir.
Okay. Are you thinking clearly today, and do you understand everything that's happening?
Just a little tired. I have 2 sick ones at home, so it's just...
But you're still be able to understand
Yeah.
what's happening?
Yeah,
Okay.
I fully understand.
Okay, so do you read and write English for the record?
Yes.
Okay, I'm going to provide to you a document. It's entitled Acknowledgement of Rights and Waiver of Counsel. It kind of goes over what I've already explained to you, but take some time to read it. If you have any questions about it, ask me. If you find it acceptable after reading it, you can sign and date at the bottom.
It's the 13th.
Court finds that Mr. Chabot has executed in open court the written acknowledgement of rights and waiver of counsel document. Okay, Mr. Chabot, before I can accept a no contest plea, the law requires an explanation of circumstances. The prosecutor or the law director filed a bond recommendation in this case, and in that had a summary of facts. I'm going to read this. It alleges that on September 22nd, 2025, the defendant failed to comply with a junk vehicle notice of violation regarding a 2019 Cobra Sandpiper camper located at 524 Madison Street in Conneaut. Is there anything in that brief explanation that you object to?
That's right about the vehicle. About it not being licensed or registered.
Okay, so I do accept the explanation of circumstances. I do find the defendant's no contest plea to be knowing, voluntary, and intelligent. The court will accept the no contest plea, and the court will therefore find the defendant guilty of this offense. Okay, Mr. Chabot, as I explained to the gentleman before you, the law director is not present at these initial appearance hearings. I don't know whether this vehicle's still there or not.
It is.
Okay.
I had sold it to my grandfather, handed the title over and everything. He is using it as like a storage vehicle, as a trailer pretty much. In regards to the junk on the property, it's my aunt's house. The junk has I have no association to the junk besides the camper that was on the property.
Okay, well, here's what I'm going to do, because the city needs to be present for your sentencing hearing.
Okay.
And they need to tell me whether you're in compliance or not, and they need to make a recommendation about your sentence. So I'm going to defer sentencing today, and I'm going to set this for a sentencing hearing in roughly 2 to 3 weeks. Law director to be present. Now, I actually issued a warrant for your arrest in this case because your whereabouts were unknown. So
Yeah.
what is your address?
1600 Lennox Newline Road. Trailer 37, Jefferson, Ohio.
How long have you been living there?
Since October, like mid-October.
How did you find out about this case then?
My mom had called me and said, just so you know, you have a bench warrant out. And then it was kind of just a couple people following after that had told me, hey, do you know that this is out there about you? And I said, I have no clue, but I guess I'm going to get on it. So.
Okay. Well, the fact that you're here today, I will lift the bench warrant and warrant block. I'll set bonds in this case in the amount of $2,500 personal recognizance. We will set this case for a sentencing hearing, as I said, in about 2 to 3 weeks. Mr. Chabot, we will give you a hearing date at the clerk's window, so you will know before you leave when you have to be back. So, and if you fail to come back, I could issue another warrant, and then I could order you to pay the city of Conneaut $2,500 as a penalty. Do you understand that? Do you have any questions for me? Okay. In the next 2 or 3 weeks, you may want to do anything and everything you need to do to comply with the city's order. And I know your allegation, or what you told me, is I've sold it, I no longer own it. Well, you just pled no contest, and you're being held responsible for this trailer on someone else's property. So
Now, would I still be held accountable for the junk on the property since it's not my address?
yeah, so this complaint only involves a 2019 Cobra Sandpiper camper.
Yes, sir.
That's all it involves. Okay. Okay. So we will see you in a few weeks.
All right.
Thank you. Okay, the court is on the record in State of Ohio versus Jonathan L. Peters, case number 26 CRB 7. The court is also taking up older cases. State of Ohio versus Jonathan L. Peters, 16 CRB 76. And City of Conneaut versus Jonathan L. Peters, 16 CRB 45. I just want to lay out a record here on these older cases. In 16 CRB 76, Mr. Peters was charged with 1 count of criminal damaging, a second-degree misdemeanor. He pled not guilty to that charge on July 21st of 2016, so approaching 10 years ago. A pretrial conference was scheduled for August 2nd of 2016. And here's Mr. Peters failed to appear for that pretrial conference. And as a result of his failure to appear, a bench warrant was issued for his arrest.
Let this sink in 10 years later. And the court still remembers. Warrants don't expire just because life gets messy. This is a brutal reminder. Ignoring court doesn't make cases disappear. It makes them worse. Would you have even remembered something like this after a decade?
That warrant has remained outstanding until today. Mr. Peters is turning himself in on that warrant. So this case is still pending. It hasn't been resolved. In 16 CRB 45, Mr. Peters pled no contest to one count of disorderly conduct on January 16th of 2016. He was given a sentence of court fine or a fine and costs. He was ordered to pay all fines and costs in 14 days. Apparently, the court scheduled what they called back then a revocation hearing. As a result of the defendant's failure to timely pay or pay the fine and costs. Apparently, Mr. Peters failed to appear for that September 20th, 2016, 11 a.m. Revocation hearing. As a result, the court issued at that time a bench warrant, again, for Mr. Peters' arrest, and Mr. Peters is turning himself in on that bench warrant today. Of course, we have a new charge filed against Mr. Peters in the 26 CRB 7 case. So I'll address this case at this time. Mr. Peters, did you understand all of the rights and plea options I explained to everyone earlier?
Yes, Your Honor.
Do you have any questions regarding those?
No.
You did receive a copy of the complaint filed against you, the new complaint?
Yes.
Okay. You are charged with one count of theft. That is a first-degree misdemeanor. If convicted of this offense, you face a maximum 6 months in jail and a maximum fine of $1,000. Do you understand the maximum potential penalties you face if convicted of this offense?
Yes.
And how do you wish to plead to this charge? And because I see some hesitation already, Mr. Peters, the court is in receipt of a financial disclosure form, which apparently you completed this morning with the Asheville County Public Defender's Office. And
So I thought she was talking about the criminal damage charge. I didn't, because the paper says that I have court next Tuesday, so I didn't realize that she was talking about this one.
so you want the public defender to represent you on the old case, but not the new case? Is that what you're saying? Is that what you're saying?
Well, I was confused because I didn't realize you guys were going to bring the new case today.
Yeah, well, you're here today.
Well,
So.
I mean, I appreciate it.
Yeah, so
but
we'll resolve it all today. But this financial disclosure form could apply to all of your cases.
Oh,
So are you asking me to appoint an attorney to represent you?
yes.
Okay. I'm going to enter a not guilty plea on your behalf to the new charge of theft based on your invocation of the attorney, your right to an attorney. I do find, based on the financial disclosure form, that you do qualify for court-appointed counsel, so I will appoint the Public Defender's Office to represent you. I will also appoint the Public Defender's Office to represent you in the criminal damaging case, 16 CRB 76. Now I have to address the issue of bond. And obviously, what goes into play in me determining what your bond is your ability to appear for all future hearings. Well, apparently you have a propensity in this court for failing to come to court when you're supposed to. So help me understand, Mr. Peters, why you failed to come to court 10 years ago when you were supposed to be in court.
I had become homeless with me, my significant other, and my under 2-year-old child at the time, and the only option option we had was to move back to Illinois with her family. And I just wasn't able to travel 1,200 miles to come to court.
So when did you move to Illinois?
I believe it was February of 2016.
Okay.
I honestly can't remember the exact dates.
And
I
when
know there was still snow on the ground.
did you move back here from Illinois?
Yes.
When did you move back?
May 5th of 2023.
The financial disclosure form has an address of 4049 Sheffield Monroe Road,
Correct.
Kingsville, with a P.O. box.
Yes.
Do you live there?
Yeah, I live with my parents.
Okay.
Because honestly, I had forgotten completely, because it's been decades, so I honestly forgot about the charges up here until the sheriff came to my door telling me about the theft charge that was going to be being put in, and it was like, do you realize that you have a warrant? And I was like, I mean, now that you say it, yeah, I remember not going to court. And he's like, well, they're from like a decade ago. And I was like, well, I guess I should go turn myself in. And then I called last Monday, and she's like, well, we can't find the one file, so just come in next week. And now I'm here.
Okay, I will lift the warrants that were issued in the 2016 cases. The law director on the new case, on the theft case, the law director submitted and that's the prosecutor, submitted a bond recommendation asking the bond be set in the amount of $5,000 personal recognizance. The allegations are that on or between November 23rd and December 25th, 2025, the defendant stole $72.57 worth of merchandise from Circle K in Kingsville Township, and is asking me to order you to have no contact with the Circle K store located at 5569 State Route 193 in Kingsville. Is there any reason you need to be at that Circle K store while this case is pending?
No, sir. Honestly, the sheriff told me that I wasn't allowed to go back, so I just assumed I was trespassing.
Are you currently under receiving treatment, the treatment services of any mental health or substance abuse agency?
No. I've been trying to contact Lark for alcohol recovery, but every time I call up there, the phone just rings.
Is Jill here?
I didn't see her, I'm not positive.
Usually we have a representative from the Lake Area Recovery Center here every Tuesday morning. I'm hopeful that she's here this morning. So I'm going to set bond in the amount of, on the new case, in the amount of $5,000 personal recognizance. You're ordered not to consume or possess alcohol or drugs. I am ordering you to undergo an alcohol drug assessment with the Lake Area Recovery Center, or LARC, and to successfully comply with any and all treatment recommendations. As I said, if there's a representative here today, she will meet with you to do the intake and start the assessment process. If she's not here today, we will give you contact information where you're ordered to contact LARC to make arrangements for an assessment.
Okay.
I'm also ordering you to have no contact with the Circle K store and to remain off the premises at 5569 State Route 193 in Kingsville Township. And we'll set this case for a pretrial conference when the prosecutor and the public defender is available to handle your case. I'm going to set bond in the criminal damaging case, 16 CRB 76, in the amount of $5,000 personal recognizance. At the time, the judge at that point ordered you to have no contact with the victim, but who's the victim? Kenneth Wood. Do you have any reason to be in contact with Kenneth Wood?
No.
Okay. Okay, we will, I'm going to order same conditions. Your $5,000 personal recognizance, not to consume or possess alcohol or drugs, subject to random chemical testing by probation and law enforcement, an alcohol drug assessment with the Lake Area Recovery Center, and have no contact with Kenneth Wood. And we'll schedule this case for the same date and time as the other pretrial and the other case. Okay, Mr. Peters, let me make something real clear to you. You know, the prior judge, he's gone. I'm the new judge. Of course, I'm not new anymore. I've been doing this for 6 years. But if you don't come to court when you're supposed to under my watch, and I issue a warrant and you get arrested, yeah, you ain't getting out of jail for a long time.
Understandable. I'll be here.
Okay, you're going to go to the clerk's window and they're going to take care of you, sir. Okay?
Thank you very much.
Thank you.